I am happy to be welcoming back an attorney who's also a friend of ours. We've actually had a couple of dinners together with him. He's super fun, and today he has decided to talk with me about mediation. There he is. About mediation when you are our clients are on some level. And so there he is. Oh, that was so smooth, Ian. I can't believe it just worked.
Let's hope the rest of it goes that smooth too.
It will. So welcome back, Ian. And I told you, and you know, because I just mentioned how we've had dinners together. So you know that we've got the craziest cases, and a lot of people think that there's no other path except litigation when you're dealing with domestic violence. Quickly, what's your opinion on that mentality?
Yeah, I mean, I think litigation is one of the worst possible places where you can be. It brings out the worst in people. It is mentally draining, it is emotionally draining, and it's financially draining. So I think with proper boundaries in place, there are alternatives like mediation that are possible even in the domestic violence situation. But I think those guidelines, those guardrails really do have to be in place to make sure that it works.
Yeah. So before we even jump into it, can you officially introduce yourself to the people who didn't see you last time? Which has been a while, I think, since we've
It
done it.
has. It has been. It has been. Well, first of all, thank you so much for having me. I appreciate it, and I appreciate everything you do for your community and your clients, especially in the way that you help with our clients that we share mutually, and the amazing work that you and Chris are doing. My name is Ian Steinberg. I am a matrimonial and family law attorney based in New York City. My firm's name is Berkman, Botker, Newman and Shine. We have about 25 lawyers in Manhattan, in Westchester, and out on Long Island. So we cover most of the geographical area surrounding New York City and therein. And my practice particularly focuses on all elements of divorce, prenups as well, but that's a conversation for a different day. But my initial background is in litigation, and I started as a real estate litigator, which gave me a lot of skills of being able to be comfortable in a courtroom. And when I made the transition over to the matrimonial and family law world, I realized that yes, sometimes litigation is inevitable and you have to have those skills, but part of knowing how things would go in a courtroom really does help you with some of the alternative resolution practices. And so I immediately took my mediation training, I took my collaborative law training, and really thought there's a better way to do this.
Yeah. And
Avoiding court.
I know from talking to you that you didn't just have training, official training in collaborative law and mediation and et cetera, but you had training from way back when you were a teenager, real life training. You want to talk about that quickly?
Well, you did use the word official, which is what my first job was as an ice hockey referee. I'm an avid ice hockey player, and my dad said, "Son, go get a job." And so I said, "Okay, I'll start refereeing hockey games." And little did he know at 14, he would have to drive me to the 6 a.m. games when I started reffing little kids. But it started more to really kind of help me with my conflict resolution. Less so with the young kids, but more so when I got a little bit older and started refing the adult league games. And I think that's where you really, you were the one with the whistle, despite being the youngest one there, and you kind of had this idea of, okay, yes, I'm in charge, but they're not going to like me or respect me if I don't do this properly, and kind of figure out how do I develop a relationship with the players while also making sure that I'm the authoritative figure while being younger than all of them. And so I think that was a really interesting, like, sort of introduction crash course into like conflict resolution and playing that sort of mediator role. It's a little less, a little more authoritative. I don't have the same whistle and authority as I would as a mediator, but it was a really good way at a young age to kind of understand how to manage some of these conflicts. Sure, it presented as screaming that I didn't get the call right, and now maybe this is screaming about parenting and asset distribution, but it's the same sort of general principles, and learning that at a really young age to me was really helpful as I matured and matured in my career.
Yeah. So we're getting a comment. I know we were going to start with maybe some misconceptions that people have about mediation, but one thing we hear all the time, which is echoed in this comment, is how family courts don't protect actual victims. And from talking to professionals, they tend to agree and say this is why we want to keep it out of court. What do you think when someone says family court doesn't protect victims?
Yeah, I mean, look, I think that the family court system in general is incredibly flawed for many reasons. It's You're in a position in which you have to sort of prove what you're wrong, how you were wronged, and just being involved of the in the process sometimes can serve to perpetuate that type of violence or that type of coercive control or whatever the case may be, simply by nature of now being rooted in conflict, and people tend to fall back into their similar types of mannerisms, their ways of handling that conflict as they did as a married couple or a together couple, an intact couple, I should say. And so I think that at the end of the day, you're sort of now pushed into a system that doesn't necessarily have the proper guardrails to protect victims, to protect parties who need that protection. And I think that's just the nature of the way the system is being overrun, being slow, being, a place that just doesn't have the ability to really provide that guidance and protection that people need.
Yeah. So I know that we often also hear people say, well, if I go to mediation, it's not going to do anything because my ex is never going to listen to the mediator and the mediator has no power. I'm sure you've heard comments like that. So let's hear your opinion on it.
So there's a couple of different ways in which we can kind of enter the mediation process, right? The general classic mediation is both of the parties are in a room with a neutral third party mediator, and that person is trying to get to the bottom of what the issues are and help work through creative solutions to get you to the finish line. Part of what I joke is that in mediation, there's some of the hardest agreements to actually draft because you've come up with such great creative solutions to these problems. And then I sit down in my computer and I'm like, hmm, how do I write that? How do I make that lawyery and legal and in a contract? And so I think that's just an interesting side note that I think of when I think of mediation. But when you're in that process, there does have to be a commitment to it, right? There has to be a commitment that this mediator is going to be the person who is going to not make the decision for us, but help assist us in understanding why our positions are what we are, to better facilitate the two of you to be able to get to a resolution that works for you and your family. And the mediator's job is to sort of regulate the conversation. It's to give voice to that, the party who doesn't have the voice as much, to sort of have the reins on, who's talking when and how we're going to facilitate this conversation. And I think that person, sure, they don't have power the way a judge has power, but you retain a mediator and you could be in their office the next day starting the process. And sometimes there's a lot of value to that. I'll also say that I always recommend when I'm mediating that each party has an attorney representing them outside of the room. So that we
Oh, I
call
was going
them.
to ask you that question. So attorney's not in there.
So that, yeah, so in the general mediation context, when there's one mediator and the parties, they're the only three in the room. But we advise that people, as the mediator, that the party should have their own attorney that they consult with. We call it, very clever term, a consulting attorney, who essentially what you do is you have a conversation with them before sessions, after sessions. You review the notes from the mediation. And when I'm in that role, I'll say, oh, okay, so this is the spousal support number that you came up with. This is the custody that you came up with. How did you come up with that? If you were in court, maybe that's something that would otherwise you wouldn't otherwise get, or you would otherwise get, or this is a good deal, a bad deal, in my opinion. And so I think that's a way that people can, okay, no decisions are final until in mediation, until there's pen to paper. And so you have this option to say, I think this sounds good in theory. I'd like to discuss it with my consulting attorney and have a conversation about it before we get to the point of actually putting pen to paper, so that you feel as if you have protection outside of the room to then bring you inside of the room as well.
Okay, so why do some lawyers insist that their clients should have an attorney present? I agree with you. I feel like with the people we work with, it's better if they can handle it to be with just the two parties and the mediator, if the mediator knows how to guide the conversation. But some of our clients' attorneys say, no, I don't want you in there without me. You need me there. Then mediators that I've interviewed have said, well, then see, the thing is, when you have clients and their attorneys, it ends up being lots more fighting.
Well, at the end of the day, that's not really mediation with an uppercase M, I would say, right? That is more attorney guided mediation, which is fine. Like and that was sort of part of what I was getting to. And I said there's different types of mediation. Like that, I would sort of call like a lowercase m
Mhm.
mediation because you are working together to have a solution or to come to a solution, but you're there with your representatives. There's been this sort of thing that's come out, which it's funny as I'm sitting in my office now, I just saw one of these retired judges walk by, but that's something that has happened a lot where there have been retired judges who have sat in the matrimonial and the divorce court for years. This one particularly, I'll give him a plug. He's wonderful. His name's Douglas Hoffman. He sat in the matrimonial part in New York County for 20 plus years, and he'll come in and he'll be the mediator and you'll be there with both parties and the attorneys, and you'll then be able to have someone who has experience in these types of issues give you guidance. If I was sitting on the bench and this case was before me in court, here's what I would do. And that's
Mhm.
not to say that those are the only people that you need to use. I think that there's a bit of cachet, especially if you're with, your soon to be ex or your soon to be ex partner is someone who needs a more authoritative figure to tell them what to do. It's a way
Mhm.
to get to a degree that authoritative figure outside of the courtroom environment. And so it's a really good option. That's not to say that there can't be, other lawyers who work in the field that could serve in the mediation with a small m capacity with the attorneys there, but we have found it to be very productive when these retired judges actually serve in the mediation capacity because they have such experience dealing with the exact issues that the parties in our given case are dealing with.
Yeah, yeah. I mean, so for my own case, I worked like you had suggested. My lawyer was wonderful. He's also suggested that it would just be me, my then soon to be ex, and the mediator. And the mediator was able to guide us, and we got so much done, even though it was a high conflict situation. Like we got the entire parenting plan done. And I remember at times my ex would insist on certain things like, well, I don't think I should have to pay child support unless I have this wonderful relationship with my kids. And the mediator's like, uh, that's not how it works. A judge would do this. So let's just come up with a number and move forward. And if I had said that, my ex wouldn't have listened. But having that authority, even though he wasn't a judge, kept us moving along. And my lawyer outside, my consulting attorney, was so proud because he said, you just saved thousands of dollars and so much time in court by getting that part done yourself. Of course, we couldn't do any of the financial stuff because there was no discovery process cooperated with, but we did get this huge custody thing taken care of.
And that is one of the great, I guess you just elicited a number of different great things about mediation. The cost savings can be astronomical. And I think that putting your money to better use, you don't want it to go to your lawyer's kids, and their college. You want it to go to your kids and their college, or you have more income that you can use to hire more relevant professionals. For me, to hire someone like you to be able to work with, that's a way better use of money than draining it on motion practice and court appearances. Like it's such a better use of those funds, not to mention your emotional, the emotional drain that comes along with it. But I think even if, to your point, that you can just knock out a few of the issues and now your world of disagreement has shrunk from 10 things to 2 things, maybe that even feels more manageable. And sometimes it's a bit of a domino effect. When one domino falls and you realize, oh wow, we actually got to an agreement on something. Let's keep going. And then you sort of build on that momentum. And ideally they just keep falling. And look, at some point it stops, perhaps. But now, like I said, you went from 10 issues to 2. That's real progress.
Yeah, and that's something we also note to our clients about how the courts really don't have time. And so when you can go in there and show that you've made your best effort to not waste the court's time, to say we got all of this done, we tried, and now we just have these 2 issues, that you end up looking better. You look more like you're aligning with the process by trying to do as much as you can by yourself. And also the thing you said about retired judges, we have clients doing that who end up doing probably very well when they have a retired judge doing the I think it's called, is it called judicial mediation? That's the term that we've heard used.
Yeah, I mean, I don't really know if it's like formalized with the term because I mean, they're retired judges who now are just acting as mediators. So we sort of call it like, attorney assisted mediation with the use of a judge. Like I don't have maybe at some point there will be a more fancy name for it, but what you just said sounds nice. Like I think that that is exactly what it is. They have the same lack of authority that any other mediator would have, but they come with a level of authority based on how long they have been, a judge in dealing with these types of issues. And especially when you're with a couple who maybe there's one side who is much more forceful and there has been domestic violence or there has been a reason as to why there's a power dynamic that's so in favor of one side. And that's the concern in mediation. Having someone with the gravitas of a retired judge can help shift that because they can say, okay, like that's great that you're acting this way. If you were in my courtroom, I would have thrown you out if you did this, or whatever the case may be. And I think that that is a level of increased protection. It's one of these potential guardrails for people who are going through domestic violence or who are going through other sort of issues like that, to be able to implement so that ideally the process can be engaged in that may not otherwise.
Yeah, and I'm thinking also we have a client who's using a retired judge as a parenting coordinator and does not like what the parenting coordinator is saying, but the parenting coordinator is using the agreement to make decisions. And I've been telling our client that even though she doesn't like what she's hearing, at least she's hearing it now without paying a lawyer thousands of dollars, making a case, and then losing in court. So better earlier rather than later.
Definitely. It's usually is money well spent because I mean at the very least if you're not reaching an agreement, you've crystallized the issues, you've knocked them down, and at the very least you're now knowing what the position of the other side is too. You know where they stand, and sometimes that could even be helpful because if you know you stand so far apart, well, maybe you don't have a choice, and at least you've figured that out now. There is another tool that just came to mind too that I have sort of utilized, which has kind of helped with the advent of Zoom, I think, to a degree, and the use of it is that sometimes there are, we have what we call like a four-way conference, which is, um, a little less than mediation because there's no neutral third party there, but it's the attorneys and the parties getting together and saying, okay, if we're in a room, the four of us, we should be able to figure this out or at least figure some things out. And where Zoom has helped is that if there are instances in which there's a power dynamic, there's domestic violence, there are people who maybe won't feel comfortable being across the table from their soon to be spouse, their soon to be ex spouse, soon to be ex partner. I think that what we can do is say, okay, there's the room for the attorneys to chat, and there's the separate breakout rooms for each of the parties to be in, and the attorneys can go back and forth from the attorney room to then a room with each of their respective clients, have real-time conversations about what was just discussed and go, okay, mom wants the extra week in the summer and dad didn't want to agree. Well, if he gets the extra week, maybe there's a way to give one other religious holiday that may be important. Okay, let's see. Go back into the respective Zoom rooms, talk about it with the client, and then come back. That way you are very separate and you're not feeling this, you know, this sense of nerve or scared or whatever it may be when you're across the room from someone who may have perpetrated some domestic violence or there's coercive control or whatever the case may be, but you're kind of negotiating and mediating in real time. So I think it's an important tool to be able to use. Sometimes the retired judges do that in person anyway, where they separate the
Mhm.
rooms and say, okay, mom or is on one side and dad's on the other side, and the lawyers like kind of stay and shuttle diplomacy type of thing. But this is really a separation, and we're using Zoom to help, make someone feel comfortable that they're not staring, whether in person or even on the screen, at their soon to be ex.
Yeah, I like that. And I also like how there's no game of telephone. So when there is shuttle mediation, or sometimes I think we've heard it called closed mediation, where the lawyer and the client are each in their own separate rooms and the mediator's going back and forth, it is telephone because it's like, well, they said they want this, but when it's your two lawyers, they're talking directly to each other and then going back. So it takes out that third person, that
Yeah.
additional person.
No, it does. And to a degree, there can be a little bit of a frank conversation between lawyers that perhaps you wouldn't, as the lawyer, I wouldn't want the spouse to hear, the other spouse
Hmm.
to hear me say, like, look, we all know your client's being really difficult, and we
Hmm.
need to find a, maybe that's not the best example, but something along those lines,
Oh,
because
that fits right here, Ian. That's a good one.
yes, I do know the clientele. But it's something that maybe I wouldn't want to say if the four of us were together,
Right.
because it may be something that would incite the other side and maybe leave it towards, maybe end the mediation there because they would be pissed. Oh, he's such a jerk. Your lawyer's so difficult. Blah. Why is he
Mhm.
saying this to me? Versus when I say to the other lawyer, look, like we can all acknowledge your client's being difficult. If you can push him on this and see if he's willing to budge, that would go a really long way, right? And maybe
Mhm.
that's a more frank conversation that lawyers can have, and then go report back. And it creates a space for true negotiation while protecting the party from those ugly feelings that may resurface if they have to stare across the screen.
Yeah. So, any other tips for like let's say I'm a domestic violence victim and I'm going to mediation and I am really really scared, and I'm your client. What kinds of things would you tell me in terms of my brain, or what documents to get together to prepare for my first mediation? What should I expect?
So I think a couple of things. First, I think my first advice would be make sure you're very well prepped with your professionals. So make sure you speak with your lawyer in advance to talk about, what things really are important to you. I would say make sure you talk with your coach to make sure that your emotions are in check, and you kind of you'll know the things that trigger you because you've been with this person for a while. What are the tools that I know, Lisa, you give your clients and things like that that can help make sure that you stay in check. I would say, maybe make a list of what the most and what all of your asks would be
Uh,
to sorry.
that's okay.
Make
I was like, oh
make
no.
yeah,
All
make
right. I
make
think
like
all of my asks would be.
yeah, make a list of what all of your asks would be. Maybe do that with your lawyer so that you're super prepared. And the last thing I would say is keep in mind that you don't have to agree to anything. If your answer is that sounds really good to me, I think it could be workable. I want to think about it. I want to talk to my lawyer about it, and then I'll come back to you. You don't have to agree. If you think that this is something that works, be honest. This may work. But in the event that it doesn't, like you don't need to say, yes, I agree to this right now. You can say, this sounds really nice in theory. Let me sleep on it. Like there's nothing, don't feel pressure to say yes, because that's probably what you were feeling during your relationship. And now you have the opportunity to have your professionals and run things by them and make sure that what you're doing, A, you're comfortable with, and B, it's in your best interest.
Okay, so here's something that we unfortunately see, and no offense, Ian, because I'm sure you don't do this, but a lot of people's attorneys get really tired with our cases, and then their own lawyer is pressuring them to settle like right then and there.
Yeah, I mean, I think a lot of like to a degree, sometimes deals get done because people are put under the gun, right? And it's kind of put up or shut up time, for lack of a better phrase. And I think, my thought is always it's better to take the day and think about it before making a decision that you'll regret. Because if you say yes right there and then you walk it back, now you're looking way worse than if you said, you know what, I
Mhm.
need a little time. I sort of liken it to if someone in a consultation asks me a question and it's about a typical, a particular type of, law or a question within our field, and I just don't know the answer. I'm not going to say, here's what it is, here's the answer, or here's what I think the answer is. I'm going to say, why don't you give me some time? I got to look into it. I maybe want to ask some other people in my firm to make sure I'm giving you the right advice. It's a similar concept, I think, where it's
Yeah.
I want to just make sure that this is what I want to do, and I'm comfortable with this, and give me a second to think about it. And it's tough. I think lawyers want to get you to a deal because that's what we're hired to do. And
Yeah.
so, but my thought is always, let me put the options out there for you. I had a case where I said, look, either you settle and you go to trial, or you go to trial. Settlement seems like your spouse won't agree to anything less than 50-50 custody. If
Mhm.
you're not comfortable with that, then you should go to trial. and I'm here for you and I'm with you. If it's something you can get behind because you think about the costs emotionally of trial, financially of trial, of how long it's going to take, things like that, and the fact that no one knows the outcome at trial. Maybe it's something that you would consider on the 50-50, but there's all these other things that you would want to get in order to give it. Let's explore that option, but don't think you have to agree. Here are
Yeah.
your options. Here are the pros, here are the cons. Make your decision. And I think that's what clients should be able to expect from their attorneys.
Yeah, it's making me think of the term, it's informed consent.
I think that's well put.
Yeah, thank you. All right. We got this question a lot earlier, but I wanted to wait till now. Are there situations where you think mediation should either stop or not even be an option?
100%.
Really? So, for example, when?
If the power dynamic is so, I'll say this, if there's a power dynamic that is so prescient and it's just something where you just know that this person would try and railroad you and you're
Mhm.
not going to be able to withstand it, it's not worth it. If
Mhm.
the conflict is too new or is too high, you're just going to get into a room and blow up and push you further away, probably not right for it. Maybe that's an instance in which we say general, typical uppercase M mediation may not work, but one of these alternative mediation type processes may be better. Maybe that's something. There's definitely cases where big capital M mediation just is not the right fit. And that's not necessarily a bad thing. I think maybe if you do want to find an alternative process, okay, let's figure out how to make that work. Let's figure out what guardrails, again, we could put in place to make it a productive out of court process. But no, there are plenty of instances where I've said, look, I know you want to do mediation. I know you think that that may be the fit based on everything you're telling me. I don't think that's the right fit for you. That doesn't mean that you should go litigate, but
Mhm.
it just means that mediation in its pure sense probably doesn't make sense.
Yeah, yeah. All right, well, good to know. So, Ian, how can people find you?
You can find me on our website. It's www.burkbot.com. My email is isteinberg@burkbot.com. And I'm on LinkedIn as well. And then this is my Ian Steinberg Divorce Law Instagram. So feel free to reach out here too.
All right, good. All right, well, thank you so much, Ian, and we'll have to do another dinner soon.
Thank you so much for having me. I'm looking forward to that.
All right, take care.
Bye.
Bye.